Pavlovska and language experts, professional development and training, educational series on who is the interpreter. And this is going to be part 4 of our series. And the title is Specialist Legal or Court Interpreting. By the way, if you are wondering where is part 3, it's scheduled to be broadcast on YouTube on the 7th of this month. So if you are going in order, series 1, 2, 3, you'll be able to see them on YouTube, and particularly number 3 will be on the 7th of February. This is a live broadcast, and this is number 4, part 4 of this series. The title is Specialist Legal or Court Interpreting. Linguists, I should say, and lawyers have identified the following additional competencies required by legal interpreters working in legal settings. And by the way, I'm referring to our publication, the Language Experts publication, a training handbook for legal and court interpreters in Australia, which is catalogued in the National Library in Australia with its own ISBN number. So linguists and lawyers have identified the following additional competencies required by legal interpreters working in legal settings. First of all, comprehensive knowledge about the local legal system and the features of civil and criminal law. Legal interpreters must understand that every interaction in a legal setting is part of the exercise of or determination of legal rights and obligations. 2, thorough understanding of the roles of lawyers, judicial officers, and prosecutors. 3, sensitivity to legal culture, including an awareness of the way in which language is used for strategic ends. Number 4, command of legal terminology and its functional equivalent in the target language. Fidelity of content is particularly important in police interviews and court and tribunal hearings, where interpretation forms part of the legal record. The interpretation must conserve paralinguistic features of the original speech, such as hesitations, false starts, and repetition. 5, an understanding of the structure of the legal system or systems and administration of justice in the countries where the target or source language is spoken. Number 6, tertiary level education or equivalent life experience, wide reading and knowledge of current affairs. 7, the ability to interpret consecutively and simultaneously in courtrooms and tribunals. The interpreting must be accurate and sensitive to linguistic nuances. The interpreter must convey everything that an English-speaking participants can hear, including comments and exchanges between parties, lawyers and police, and procedural directions. The style in which the message is conveyed is also crucial or critical. The lawyer, judge, and jury should react in the same manner to a non-English speaking background person, witness, as they would to an English speaker. Linguistic and vocabulary choices convey information about the client's socioeconomic, educational, and cultural background. And this shapes the lawyer's responses and the views of the judge and jury about the demeanor and credit of the non-English speaking background party. Number 8, commitment to ethical principles in legal settings. And number 9, an understanding of the expectations of lawyers and how to work professionally with them. As I said, these are the opinions of linguists and lawyers. they've identified these additional competencies required by legal interpreters working in legal settings. Is that your view as a practitioner? Australian interpreters who work in legal settings do not necessarily have these competencies. If we accept that there is a need to improve the quality of legal interpreting in this country, in Australia that is, we will need to consider some form of specialized training for legal interpreters. And this handbook has been specifically produced to address this issue. And by the way, Language Experts provides professional, preparatory, and recertification training for practitioners of interpreting in Australia and has been doing so for more than 20 years. And there is such a course called Legal and Court Interpreting in Australia, developed and delivered by Language Experts. If you are interested in any of our training, that is the training to do with fundamental skills, with specializations on ethics and so on, you're welcome to write to us at training@languageexperts.com.au with your request. And we welcome your membership to our family of lifelong learners in Australia in particular. To define what is required for such specialization, we must be clear about the levels of demand for legal interpreting, the availability of candidates, and the content and variety of legal assignments in an Australian context. Fully defended criminal proceedings, for example, undoubtedly do require interpreters who have sophisticated legal vocabulary, speedy delivery, and a solid grounding in legal principles and practice. The requirements of other legal settings may be different. There is a claim or an assumption that once higher order competencies for legal interpreting have been identified, the need for specialized or specialist legal or court interpreters is obvious. These claims and assumptions proceed on three grounds. First, that legal interpreting means court interpreting. Secondly, that court interpreting is quite unlike any other form of interpreting. And thirdly, that court interpreters must be tested and accredited separately from general interpreters. Such assumptions are inherently flawed. The use of court interpreter as a generic term reflects the law's own regard for the appellate court as the apex of the legal system. However, more recent views of the operation of law in Australia suggest that the courtroom has a much more marginal role in the determination of legal rights and obligations than classical theory allows. Most legal proceedings involving non-English speaking people are dealt with initially by a private or community service lawyer and then by a specialist administrative tribunal, which determine entitlements on the basis of simplified fact-finding procedures. Even where matters go to court, those cases are almost always dealt with simply in a summary jurisdiction. Cases involving non-English speaking background persons in higher courts, which cover complex issues of law and procedure, are much more infrequent. For this reason, the more accurate conceptualization for Australia is the wider, inclusive one of court interpreter. We have quoted Laster and Taylor at some length because their account is one that succinctly identifies some of the core debates for the interpreting profession in the context of practicing in the Australian legal system. The section quoted has significant ramifications and implications for a number of core issues. 1, the professional duties of the interpreter. 2, the professional competencies of the interpreter. And 3, legal system contextual issues crucial for the professional interpreter. It is an illuminating exercise to do a systematic comparison between what interpreters and the legal system list here as competencies and what liaison interpreting has listed in another chapter of our book, namely chapter 1.1. The comparison enables us to identify the perspectives that derive from the interpreter as a professional practitioner versus the perspectives that derive from how the legal profession would like interpreters to fit into the legal system. Indeed, from this we can extrapolate in a more general sense that definitions stemming from the profession itself will vary from definitions derived from the other professional domains in which interpreters work. It is very important for interpreting practitioners to fully recognize this reality, as it is at the core of virtually every conflict of expectations professional interpreters can encounter in the course of their work. Quite simply, the conflict that arises from what we know we should be doing versus what others think we should be doing. A full understanding of an interpreter's skills and competency is tied to questions of the professional duties of the interpreter, the recipients of the service, and the professional ethics that are derived from the duties. A code of ethics for any profession will not be considered credible if it has its paramount guiding principle a definition of its professional skills and competencies and the duties derived from same. These issues are examined in chapter 3 of our publication. And before we examine this in detail, we are going to look at the vexed issue at the core of legal interpreting arising from the particular way in which language is used in legal settings. Well, interpreters are often expected to interpret literally or word for word. You've heard that, haven't you? Word for word, Madam Interpreter. This idea has caused and continues to cause much anxiety and confusion because both in linguistics and in the law, it can mean two different things. First, it can mean to give the exact meaning of the utterance from the source language into the target language, or it can give the exact words and structures of the utterance from the source language into the target language. The concept is also expressed by the notion of the interpreter as a conduit pipe between the source language and the target language. This notion has been in existence in Australia since the 1960s, and unfortunately, it still prevails. Laster and Taylor give an account of how this conduit model developed in another section of this publication. And this concept rather gives the idea that interpretation is like running water, which can be turned on and off without the interpreter being involved in a myriad of decisions about how culture, how context, how situation and dialect affect meaning, let alone how idiomatic, colloquial and figurative language really works. Laster and Taylor do not subscribe to this simplistic and misleading approach, and neither do we at Language Experts. Note that they refer to functional equivalent. And this concept of functional equivalent has been used by many theorists and practitioners as well, among them Nida and others. Functionality is the key idea. All interpretation must fulfill the purpose for which the source language and the target language are used, not only in legal settings, but in every single setting where interpreting as a professional activity takes place. There may be specific cases where, due to cultural considerations, the exact words and structures of the source language will need to be transferred into the target language, and in those circumstances, the judicial officers or lawyers will provide clear instructions to the interpreter. Note that Laster and Taylor have pointed out previously that language is used in legal settings for strategic ends. Halliday would also probably argue that all language used in real-life situations has a strategic element to it. Quite simply, we use language to accomplish practical things, like solving a problem, negotiating a deal, imparting information, teaching and training, expressing attitudes and feelings. What Laster and Taylor emphasize are the particular ends, the purposes for which language is used in legal settings, that is, the exercise of or determination of legal rights and obligations. We need to understand the specific purpose during any legal proceedings for which all the participants use language in particular ways in both languages. The judicial officers, magistrates and judges, lawyers and barristers, prosecutors and police officers, defendant or defendants and witnesses. In another chapter of our publication, we have written about examples of legal language and discuss the implications for the practicing interpreter. And we will do so in another broadcast on this aspect, what is legal language, in another part of our series on who is the interpreter. This will now end this part number 4, which you will be able to see again in replay if you so desire. And thank you very much for your attention. And next time we are going to look at, is there an automatic statutory right to an interpreter in Australia and the world, specifically in Australia? We are going to look at that issue, and I'm looking forward to seeing you then. Thank you for your company. See you soon.